summary, it's taking pressurized liquids or gases like nitrogen, you stick them down in the well, and it fracks, it breaks up the rock formations to release the gas or the oil. Sand is often pumped in with the fluids to help prop the fractures open. So a lot of water goes in, sand, chemicals, and you frack it, break up down there in the bedrock. There's a picture of the fracking process. It's going very, very far down and horizontally, which is, sort of the newer technology. There you go. So you can see, it's going really much further down than traditional welling techniques. And they frack it, and you have to use just a lot of water for that. So there's your horizontal drilling. This is a picture of, obviously the casings where the water is going down. If you, ask the oil and gas industry, you can see the multi-layers of the casing. And so I think, that's where the position that, these are very safe. As far as the materials getting out, that it's bound very tightly. So that's a picture of your casing there. As I said, since the 50s, fracking has been used in approximately 2,100 wells in Southwest Virginia. Some exploratory wells were drilled in the eastern part of the state. A lot of people don't know that. But at that time, they were plugged because they weren't commercially viable. I know there's some question, even with the Taylorsville Basin, whether or not actually economically viable reserves will be found. That's sort of the question I think that's sort of out there. Even if companies can and have leases to frack, will they, tomorrow, next year, ever, because of economic viability? So I think it's good that we're all on the front end of this. Some people are saying, well, you're worried about something that will never happen. I can't say, but obviously when it becomes economically viable, it's going to be on your doorstep if you've got those reserves in your locality. Right now, there are no gas or oil wells producing outside of Southwest Virginia that I know, or that DEQ had. This is information from DEQ's website. I'm sorry, DMME's website. So if you want any additional information or if it's updated, please visit DMME's website, and they've got a great history on how fracking has occurred in Virginia, what the process is, those types of questions. As I said, with new technology comes new opportunities. The Marcellus Shale, that's the rock formation that's primarily in Southwest Virginia. It runs Pennsylvania, Virginia, Southwest Virginia. Again, according to DMME, the state believes much of the natural gas there present there at one time has pretty much escaped. So again, I don't know whether that's true or not, but that certainly is the state's position. The Taylorsville Basin is located beneath King George, Westmoreland, Caroline, Essex, and King and Queen, for those of you, and I'm sure those of you from those localities are very aware of that. And so that is when we're talking about the new the issues that are raised in Virginia now for the eastern part of the state, it's primarily the Taylorsville Basin. And there you can see, and I'm glad that slide hopefully is showing up well enough for you, the Marcellus Shale in the blue, and then the Taylorsville Basin up here. And again, DMME's website. And again, this is taken from the Fredericksburg paper. It's believed that natural gas companies have secured leases on approximately 84,000 acres of land located beneath that Taylorsville Basin. Does that mean that fracking is going to come today, tomorrow? Not necessarily, but if that's true, then there's the potential for 84,000 acres. So what are your land use concerns? Well, y'all are all planners or, in the planning business. You can come up with a list that's probably 10 slides long. We could all sit here and then people would come to you in a public hearing and you'd hear concerns that you didn't even know you had, and then they are good concerns. So, the list goes on and on, but truck traffic, visual impacts, road destruction, noise, property values, ecological impacts, water quality and quantity, Chesapeake Bay, health and safety, everything. The list just goes on. I wanted to see how many of you are actually awake after lunch, and some of you are. Give your, I think people do think the zombie apocalypse is going to be caused by fracking. So you can try. So yeah. So I think one of the greatest concerns, and all of those are valid concerns, maybe not the zombie apocalypse, but but noise and roads and trucks, those are serious concerns. But one of the primary concerns that and we see those concerns with land use, for many zoning applications that you get, but the amount of water that's used to frack a well, there you go. Typically 300,000 gallons of water to frack a well, and that's for the whole fracking process. Again, I'm not an expert. It's my understanding that the actual fracking process doesn't take a long time to actually get it down there. So it's 300,000 gallons over several days perhaps. So it's all very different. But Marcellus Shale can use up to 4 to 5 million gallons of water to frack a particular well. Again, you can go on various websites and see where the usage is, but so it's a lot of water, and so the questions are, where is it going to come from, where's it going to go, and how do you get it in there, how do you get it out of there? All good questions. Yep, that's from D and me. Okay. So, this is outside of the zombie apocalypse. I mean, these are the trucks. These are pictures. That one's not. That's just a drought picture. But concerns, safety, blowouts. This one is actually associated with a fracking, website. So this really is how up there, and I think from Pennsylvania, what some of the traffic impacts might be. I mean, how are your roads going to handle that? So who regulates fracking in Virginia? Well, potentially a lot of entities. The state operates it through the Virginia Gas and Oil Act, and then you've got regulations that have been promulgated under that act. Then you've got board regulations. You've got the state water control law, which is through DEQ, and then you've got the pollution elimination system regulations, which are also through DEQ. Those are your water regs, and then you've got additional requirements for the tidewater region. So one would think this is fairly strictly regulated, and maybe I was surprised, maybe I'm not surprised anymore, but there aren't as many regulations coming out of DMME as there are from DEQ, and so when you look at the DMME regs for fracking, it's a tiny little collection of regs. So is it regulated by DMME? Yes, it is. To what extent? Go and check for yourself what you think. Again, much more with DEQ, but we'll talk about that. Generally, the DMME requires a permit, and they have to submit an application with a plan showing all of their operational issues. They have to post a bond payable. This is important for those of you paying attention here and worried about these types of things. The bond is posted to DMME, ensuring the operator shall faithfully perform all of the state requirements for the operations plan. Not posted to the locality, not posted to ensure that if anything happens to the roads or the environment or anything else, there's a bond to cover it. This is important because when we talk at the end about what's inconsistent with state law, question, is it inconsistent to require for the locality to require a bond if there's already a bond here to the state? I don't know the answer to that. I think that's huge. There you go. The bond amount can't be less than $200 or more than $1,000 an acre. If there's a blowout or destroyed roads, is that enough? There are notice and public hearing requirements. And that's pretty much, it as far as the locality. I may be summarizing a little bit for the purposes of this presentation, but there's really, not a whole lot particular to the fracking process. as far as the eastern part of the state, there's no drilling in the Ches Bay, great, and none in an RPA or 50 feet from the shorelines of the water, which is good because we don't want this to happen because that would be bad. So for drilling in the Tidewater region, in the areas of Tidewater that aren't included in the previous slide, the applicant does have to provide an environmental impact assessment, otherwise known as an EIA. It has to be submitted to DMME with the application. It's reviewed by DEQ and other appropriate state agencies. And I will tell you that the EIA has to include all of these things, probabilities and consequences of accidental discharge of oil and gas on, various interests, and these are just a summary. I'll tell you, those EIA regulations, if the DMME regulations are like this, DEQ's regulations are like this. I mean, it's pages and pages of good stuff. Everything you could ever think about are included have to be included in that EIA for DEQ to take a look at it. So that's terrific. But DMME must consider DEQ's findings before a permit can be issued. It doesn't have to follow any of them. There is no requirement after all that EIA is submitted. Great information. DEQ, Department of Forestry, everybody else looks at that and they can come back and say, here's what we think. Here's our list. And DMME can, not required to, do anything with it. And there's an MOU that was entered into fairly recently to kind of try to tighten that up, but I think that when it was suggested that perhaps DEQ and the other state agencies' recommendations become mandatory, it was rejected by the state. So just so you know, not required to put anything in the EIA. What about local laws? Can localities adopt additional regulations? As always, we come back to the Dillon rule. What do we have the authority to do? We can only do what's expressly granted or implied by the General Assembly. 15.22280, sound familiar? That's sort of your general zoning power. But it says, among other things, subsection 1, the use of land or structures for uses can be restricted. And also number 4, the excavation of mining or soil or resources. So it appears that we're good under the Dillon rule. We have the authority to regulate fracking. In fact, there was a case, Resource Conservation Management, that looked at this statute where Prince William County sought to ban landfills. And the question was, well, can they ban a landfill use? And the Supreme Court of Virginia said, well, yes, they can, and they relied on that statute. So you can ban it all you want to. That's important. Go to the Herring decision or opinion that was just issued, and he relied on this case. So while that's true, you may have authority. The second question is, well, even if you have authority, is there anything in state law that preempts you? That means that if the General Assembly has expressly preempted the field, or where they have expressly said, well, even if you can generally do it, we're going to preempt it anyway, you can't do it. So while localities may have the authority to regulate fracking, it can't do so if it's preempted. Is it preempted? Well, if you go to 45.1-361.27, the state regulations, all those regulations that I put up before, is the field preempted? Or do we have so many regulations that somebody would say there's nothing left for localities? We've got all this stuff. There sure are a lot of regulations or some language there. But this particular statute has, which I'll reference, I won't read, even though we have all of that, state law says no provision of this chapter shall be construed to supersede the jurisdiction of local land use ordinances. So we can't do anything else except under our local land use ordinances. Everything else is preempted. So to the extent localities are going to regulate, they're going to have to do it under zoning, because otherwise it is preempted. Also, the Mark Herring decision also made that point. Other than zoning, we're preempted, local governments. And so even if it's not preempted, we still have the question, you still can't be inconsistent with state law. So we're okay under the Dillon rule. We're okay, we're not preempted. But the third little prong there is, okay, but still if you have a regulation, it can't be inconsistent with state law. And Mark Herring also had put that in his opinion as well. So again, resource management said that you could, you can ban activities. I don't want to get into these too much. I'll let you know there was a case after that, Blanton versus Amelia County, and I'm super familiar with this one because this was a case that I was involved in, and we lost this case, and it had to do with the land application of biosolids, and the issue was, could Amelia County ban the land application of biosolids where the state had issued permits, and the Supreme Court said no, that the locality can't ban that which the state permits. Question, if the state's going to permit a landfill and the locality bans it, how's that any different than the resource management case? Wasn't discussed. So these two cases are very contrary to each other, and they have not been reconciled. Okay, so we've got two cases kind of going two different ways. What about the AG's opinion? Some of you might know this. There was a 1993 AG opinion that said that the Virginia Gas and Oil Act does not exempt the permit holder from a requirement under a local zoning to obtain a special use permit. So again, speaking to zoning and recognizing that there is some broad authority, at least for issuance of special or requiring special exception permit. Then we got an opinion 2013 from Cuccinelli that said opined in summary, local government can adopt zoning provisions that restrict the location and siting of wells that are reasonable and consistent, but it cannot ban such activities outright. And so it was at the bottom, the AG concluded a locality's delegated power is limited to the ability to adopt reasonable siting regulations for gas and development activities. So more restrictive than the previous opinion that said, well, you could require special exception permits. This one just saying very narrow, you can just do siting requirements. That was what we had until just a few weeks ago. Mark Herring issued an opinion. The General Assembly intended for localities to retain their authority to prohibit fracking through duly enacted zoning ordinances. Other types of local control over fracking that do not relate to zoning, such as license or fee requirements, those are preempted. That's what we were talking about. To the extent that the 2013 opinion conflicts with this conclusion, it's overruled. So everybody who kind of always asks, and we talk about it, what is the value of these AG opinions? And we as lawyers say, well, that's one lawyer's opinion. And I think this is like a brilliant example of, oh, that's his opinion, we just overruled that. Locality has the authority to regulate fracking under zoning powers, but cannot be inconsistent with state law or unmeasurable. I think that's unreasonable. Sorry, spell check in scope. Ultimately, they're going to be decided on a case-by-case basis, and I would agree with that. There are a couple of statutes I'll just point you to. Some you might be aware of. Section 1-248. Well, that's by statute. Zoning, local ordinances can't be inconsistent with state law. I love this one. We argued it in the Blanton decision, and somehow the Supreme Court just ignored it. 15.22315, which says that if you've got, any regulation that is adopted under zoning where there's another regulation at issue, whichever is more restrictive controls. So that seems to answer the question to me. But as I said, that didn't rule the day in the Blanton decision. So what can localities do? I don't know if we want to go here. We might come back to that conversation. I don't want to take up all the time, so. Okay. I'm sorry to go through this so fast. There's just a whole lot, and we can come back and ask questions, because I did want to give you, since it's a legal seminar, a good legal overview. So what can localities do? That's, I'll tell you right now, I don't know. So if you're waiting for the slide that says this is what you can do, you can leave now, because there is no such slide. Or we can just, come up with can you restrict zombie apocalypse? Maybe, traffic, maybe, bonds, I don't know. So complete prohibitions on fracking remain subject to challenge. And again, for localities that are that are interested in banning fracking, having that hearing decision now is wonderful. But again, you've got the Cuccinelli decision of 2 years prior, so there are legal arguments both ways. So it's not a slam dunk, it's just one other lawyer's opinion. And so I think, whether that challenge is upheld is good if somebody decides to, rely on the hearing decision and that analysis and the codes that are at issue, whether they're upheld, depends on whether, in my opinion, the Supreme Court's going to follow that resource conservation, the banning of the landfill, or whether it's going to follow Blanton, boo, because I was decided totally wrong, and say, well, if the state issues a permit, locality, you can't go and ban what the state has issued a permit for. And interestingly, so you'd say, well, just ban it before the permit's issued. Bingo, did that in Appomattox. Appomattox was sued for doing that, for doing overlay districts and having requirements before the permit was issued, and we argued that case also, and we lost that case also in the federal court before Judge Moon. And I won't go through it, but so Supreme Court said you can't ban that which the state has allowed, and Judge Moon in the O'Brien versus Appomattox kind of took it one step further and said, even if you're doing it before the state issues the permit, you can't. In that case, it was an overlay district. There were some supplemental development regulations. It wasn't a ban, but it was very restrictive regulation, and the court struck those down. I would note we were in a terrible drought year too. Farmers needed biosolids, so I don't know if that had anything to do with it, but both of those cases, didn't go local government's way. I think the court's going to be guided by the express statutory language. The statutes that deal with landfills and the permitting of landfills, and the statutes and regulations dealing with biosolids, and now the state statutes dealing with hydraulic fracking are all slightly different. And so, the lawyers are going to have to argue the intricacies of these statutes. You're going to have to look closely at what does the statute say? What do the regulations say? And I think it's going to be, English major, love it. It's all coming down to wordsmithing. But I think that's what's going to rule the day, because the question is, what did the General Assembly intend? So what did the General Assembly intend? Did it intend to treat fracking like landfills or like biosolids application? And that's going to be up to the Supreme Court. Not I or any Attorney General, can make that decision. What about special exception permits that may be denied? I think special exception permits, as far as they go, are generally, treated as an acceptable tool, except when they are constantly denied as applied. Somebody comes up for an SE or a conditional use permit, denied, or within the permit the conditions are so onerous that you're effectively banning it. If that's what localities are doing, using the SE and conditional use process to do the same thing, that's going to be a problem. So could you do an SE? I think courts generally, Judge Moon probably would have said yes, that's fine, except if you get all those conditions, maybe not. So that's a perhaps in my view. So the question to me really is whether valid zoning restrictions adopted under the Oil and Gas Act, that bold language that I said, this is where we still have our zoning power, are they going to be inconsistent with state law? And Attorney General Mark Herring had said that's going to be on a case-by-case basis. So that's when he also said in that opinion, we recognize that state law and local laws are going to overlap, and so this is where we all have to be careful. We know what the state's doing, and sometimes, roads and things like that, local interests, but sometimes when you get in there, particularly things, bonds or buffers or, things where we do both share those interests, that's where we have to be cognizant that it might be inconsistent. Is it too inconsistent? So additional regulations on fracking may still be subject to legal challenge. So I think we've got Cuccinelli and Herring both saying siting requirements are fine. So that I can tell you. If you want a black and white answer, I think it is that siting and locational requirements are likely okay. But then once you kind of, pick that apart, what does that mean? Setbacks, limitations on noise, traffic restrictions, hours of operation, landscaping requirements. I mean, you're gonna have to look and see, as I said, the permitting process to get a mining permit. What does the state require? What do they look at? What do they consider? When you're looking at what regulations might you be interested in, go ahead. See what the state does. Is the state looking at buffers or any other requirements in their permits? And if you see that, hey, look, they've already talked to that issue, just realize, hey, put a red flag. That might be something that we might need to be careful. Conversely, if they're not talking about traffic restrictions or hours of operation, that might be fair game. I would say the caveat to that is, and this was argued in that Blanton biosolids decision, well, if it's not there, it's because the state didn't think it was important to put it there. So sort of like the negative to that. Well, if they had thought it was necessary, hours of operation, it would have put it in the permit. It's not in the permit. For you to put it in the permit, that's inconsistent. That's been argued. I just put that out there, that sometimes, the lack of a requirement, can be argued to be, well, you're being inconsistent. More stringent requirements on bonds. Again, there's that bond requirement that the bond be posted to DMME for, to ensure compliance with state regulations. Can you require a bond to the locality for everything else? You'd sure want one, I would think, or something. So can you get it? I don't know. Other environmental measures to protect water quality, linear requirements for wastewater pits may be problematic, particularly where EIA addressed these issues and DMME failed to include. I mean, remember, if you're in the Tidewater area and they've got this EIA and they've provided all of this, and DEQ's done a tremendous job and they've pointed out this is a problem, this is a problem, this is a problem, this is a potential problem, and DMME says nope, 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 nope. And then you come along in the locality and say, well, this is a problem, this is a problem, this is a problem. Is that inconsistent? Because again, it's even more illustrative that DMME has looked at that and rejected it. So is that inconsistent? Just something to think about. If you're in that area, look at the EIAs. You got to do your homework with these when you're crafting regulations. So again, the question is whether or not these zoning restrictions would still be found to be inconsistent with state law. So do your homework, find out what state law requirements are, get comfortable with where you are outside of that, where you're crossing the line, and then choose your battles. Current regulatory update, I will tell you that in the fall of 2013, DMME initiated a regulatory action to review its requirements for drilling. This came out of the General Assembly where I think there was a proposed moratorium bill that failed, and so people thought, well, can we fix this through regulation? And so DMME established a regulatory advisory panel, and I was asked to sit on that panel along with my colleague Eric Gregory from King George, who did a tremendous job. And so, but the charge of the RAP was very limited. It wasn't, fix this, or what are the problems that you see. It was, should the regulations require chemical disclosure? Should industry best practices be required at the state level? And then to review and determine if additional requirements are necessary for different regions of the Commonwealth. So that's what the RAP looked at. We made a bunch of recommendations there. What you think, yes, we want to know what the chemicals are there. Yes, we want additional oversight. And I think everybody in the room really agreed to that, even folks from the industry. We did suggests that local government certification of conformance with local zoning should be required. In other words, if, get that on the front end, make sure it's allowed before you can even apply to DMME. And we suggested that provisions should be included to ensure that DEQ include in its permits the recommendations of the EIA. I don't think that is in the final recommendation. I think that made its way right out. So we still don't have those good EIA regulations in there, which is a shame. And DEQ representatives were part of that group too, and I think they were not happy about that either. If you want more information on those regulations, they're at the town hall, and that's it. So I will toss it to my colleague.
Paul from Washington County. We had basically about a 5-year process. It's still going on to a certain extent. So what I like to do, Ann's touched on a lot of fantastic information. I want to give you a little bit of detail about the process we went through, some of the things we saw, some things, if you have to go through this, what you might be able to expect from supporters and oppositions, and some of the stumbling blocks we found. So the first thing when Jonah asked me to do this is like, how in the world do we condense 5 years of information into 15 to 20 minute talk? So one thing our director of planning did early on, she established a Dropbox location. So if anybody's interested, if this fascinates you, if it's happening if you're in your locality, or if you can't sleep at night, everything Washington County received or produced throughout this 4 to 5 year process can be located in that Dropbox site. So you'll find everything from draft ordinances to DMME regulations to emails from concerned citizens. So everything we saw went to that location. So again, it's a good repository if you need that sort of thing or if you'd like additional information. Back to what Ann said, this is nothing new for Southwest Virginia. One of the big points in Scott County and Washington County, there's actually an area called the Early Grove Gas Field. It started production in 1931. That area produced natural gas for about 3 decades before it was shut down, and currently is being used for natural gas storage in our area as the backwash to some pipelines that go through the area. Going forward from there, in Washington County specifically, there were several gas wells drilled, exploratory wells in the 1980s, without county approval. So that's where really, in the modern days, our issues started. And then probably late 1980s and the early 1990s, for those of you that are in the Taylorsville Basin, we saw the same activity. Gas companies started buying up and leasing gas rights to people's property. So that was kind of the precursor that you knew something was coming. 2010, it really picked up because we got basically a request from a law firm representing a drilling group that they wanted basically an analysis on our zoning to say, you need to tell us specifically, can we or can't we do this in your county? So as we went through that process, naturally our zoning determination was that extraction was not allowed in A1 and A2, which are the 2 zoning districts they were most interested in. Based on that decision, our Board of Supervisors gave direction to land use saying, okay, we know this is going to become an issue. We know this is brewing. Let's start looking at it. Let's start learning what we can about the process. That was followed up in 2010 in August. The Board of Zoning Appeals basically affirmed that decision. And even though they had the right to pursue that legally and appeal that, they did not. So the county basically relaxed a little bit. So, okay, this probably isn't as driving issue as we thought. Then in 2012, the Land Use Steering Committee continued meeting through 2011. In 2012, the Gas and Oil Board and DMME put together basically a program that the Board of Supervisors went to at John Battle High School, which is a 3-hour presentation to the board members, to staff, and to any community members that wanted to be there about the benefits and the safety of gas extraction. And so that was really the shot across the bow that we saw that, okay, they're serious about this. There's industry push to get it done. In February of 2012, after we looked at it, the Planning Commission made a recommendation to the Board of Supervisors basically to hold off. We're not under a lot of pressure. There's no deadline here. EPA was heavily involved publicly about some reports they were going to be presenting on the safety and implications of hydraulic fracturing in the United States. So we felt it best to wait. Let's see if there's some scientific evidence that can lean us one way or the other, because at this point it was still a safety issue. We still thought we had the right as a county to say, no, you can't do this. It wasn't permitted. Naturally, what the gas companies came back and said was that, well, but in our zoning districts, it allows for transmission and distribution lines. So they said that extraction was akin to distribution and transmission, which again, eventually we said, no, it's not. And then they made it say it was akin to water wells. And if you allow water wells, you can allow a gas well, which again, we said, not even close. Thanks for trying. So all this goes through, and then by November 2012, there's more interest going on, more people getting involved, a lot of independent meetings going on here. Community organizing meetings are going on in the background as well. And they had a second, basically, if you will, an educational session for the Board of Supervisors and community leaders. Very pro-gas, very safe, this is something you can have in your community, it's not going to cause a problem. They did allow the opposition to present for some time there as well to raise questions they had and concerns. Then in 2013, the rules changed a little bit because that's when A.G. Cuccinelli's opinion came down. And the county then went from looking at trying to understand all this technology and what all was going on, trying to become, if you will, an expert in hydraulic fracturing, and whether we want to have it or not. Now the argument was, well, you have to let them. So now the scope of the impact has changed dramatically, and we're considerably moving our mindset from, is this something we want to have, to how can we manage basically the siting requirements. So it's really a gear-changing event for everybody that was involved in changing our thinking and how we were going about it. November of 2013, the Land Use Steering Committee forwards a gas extraction ordinance to the Planning Commission. In 2014, we start taking up bi-monthly working sessions and meetings in regards to the draft ordinance. We work on it for quite a bit of time. We'll talk a little bit about the supporters and the opposition, both that we saw. And basically in May, both sides make presentations to the Board of Supervisors. Political pressure starts picking up, to be honest, that we need to move along, we need to make a decision here. And then in June of 2014, the Planning Commission voted 5-1 to at least forward the draft of where we were at. We were very clear we didn't think we were done. Fatigue was relatively high with everyone by this point. We had already been working on it for 3 to 4 years. Really tough getting consensus amongst the board members when we're talking about safety. And truthfully, a lot of things that people were against to begin with, they didn't want to allow it. But in a situation where they're being, if you will, forced to, it's tough to get consensus and opinion from the Planning Commission to get that done. Long story short, here's the surprise ending. All these years put into the ordinance, at the end of the day, the Board of Supervisors won't enact it. They basically completely table the draft ordinance that the Land Use Steering Committee and the Planning Commission had worked on in favor of 6-word change to our zoning ordinance. Both in A1 and A2, 3 words were added. Allowed by a special exception permit, SEP. So there's really no restrictions or no requirements in Washington County currently. Disheartening, as you can imagine, after all the work we put into it. So this is what we wound up with. Everyone with stacks and mounds of paper and more information from DMME and gas companies and opposition groups than we ever thought we could possibly digest. So major stakeholders there were the opposition, and we saw Organized Virginia a lot. They were involved very early on. Honestly, they were very professional, very cordial in their dealings with us and with staff. They were very well organized in getting people to meetings. We saw more people in our first hydraulic fracturing meeting than probably we had seen at all of our Planning Commission meetings for the last 5 years combined. So be prepared for that. They did organize protests at Board of Supervisors meetings, whether hydraulic fracturing was on the agenda or not. We would see upwards of 150, 200 people show up to protest the Board of Supervisors meetings. They did provide a lot of research to us. In essence, we'll talk about another ordinance in Colorado that I thought was very helpful that Organized Virginia actually brought to us. Says, hey, you guys should look at this. We think it has some good information. So there was definitely some value. The talking points from the opposition are very consistent. Water, water, water. 99% of the time, that's what they're arguing about. Water quality impacts the aquifers in our rural communities. The pollution, primarily from the drilling chemicals, which the companies currently are not under any requirement to divulge. And the byproducts. You put a few million gallons of water in the ground, it's got to come out, and you got to do something with it. We are on the south end of the Marcellus Shale geology in our part of the state, so we're looking at possibly a couple million gallons of water to frack an individual well. And that could translate to hundreds and hundreds of wells in the county if it goes down this path. Ann touched on roads, a lot of discussion about roads, quality of roads in the area that they were proposing to do this. They are country roads. They are narrow, and in some cases 2 cars can't pass very well. So a lot of concern with the size of the trucks and industrial equipment that's going to be on those roads. Quality of life always in a rural area is a big topic of conversation. Wildlife, a lot of livestock and agricultural issues, a lot of wells. There is no public water in these areas. So if you take the argument of contaminating your water supply, how far that extends into your agricultural community, there's no option for them beyond that. So it can have some pretty wide-reaching implications. Tourism, nobody comes down the Mendota Trail in our area to see gas wells. And adjoining landowner rights, and I'll tell you there's a converse to that with the supporters. Supporters, Gas and Oil Board was very involved. DMME was an avid supporter. The gas industry and their talking points are very consistent as well. Energy independence, the economic impact that this will create jobs, this will create tax revenue for the county once it's in place. They'll talk about the safety and the history of hydraulic fracturing, particularly the fact it has been around for decades and decades and decades. They'll talk about property owners' rights, that if they have gas on their property, why don't they have the right and opportunity to remove it and make a profit from it? And they'll talk a lot about it being a clean energy source. Other stakeholders, National Planning Commission, Board of Supervisor, Board of Zoning Appeals, all these folks were involved at some point, most of them heavily throughout the process, the State Water Control Board, the DEQ, and then most importantly, citizens and businesses at large. There were a lot of people that weren't there supporting the gas industry and weren't part of Organized Virginia, that were involved in various aspects across the spectrum of strong supporters to strong opposition. So again, we saw a tremendous turnout from our community. Again, it's not typical for our community at these types of meetings. A couple of things that we thought was key about the ordinance. One was protection of karst features, limestone caverns, dolomite extractions, marble, a lot of things we have that are draws to tourism, rock climbing and stuff in our area, we thought was very important to look at. Baseline environmental consulting services. And again, the ordinance wasn't enacted, so none of these have been tested legally, and Ann's already touched about some of that. But we felt that DMME was rather weak in how they were addressing the situation. When we did the math, they told us how many inspectors they had versus the number of active gas wells in Southwest Virginia. It worked out to one inspector per about 3,000 or 4,000 wells. So again, bad math when you start looking at how well could they provide oversight, particularly for the active drilling component of the process. We did try to address as an overlay district. We picked an area that was the most rural, least populous area in our county. Coincidentally, it was also the area the geologists and the gas people said was most likely to produce gas. That way we thought we could start, try it, see how things worked. If it did go well, then we could expand it in other areas of the county under some sort of control. And another big component was that we set back from the North Fork of the Holston River because of water quality and runoff concerns. We did feel like we basically set a 1 mile baseline on either side of the center point of the river where no drilling would be allowed. Now keep in mind, controlling the siting doesn't control where the drill goes under the ground. So even though they may be 1 mile from the river above ground, they easily can go under the river and further horizontally once they get the drill in the ground. A couple of things we went through, we especially talking about emergency procedures, making sure that the drillers were involved with our emergency preparedness, what happens if there's a problem. We also talked about decommissioning plans. We talked a lot about bonding. We actually pulled that from some other ordinances, again, never legally tested, but we felt like what DMME required was woeful as to what they would be incurring if there was a problem with the drilling site in our part of the state, particularly with how could you provide water to the locality if you did actually contaminate the water supply. And there is some evidence that has happened from time to time. Now again, both sides will tell you wildly different stories about what can possibly happen, but if the truth is somewhere in the middle, a well can fail from time to time. Some of the lessons we learned, very technical. We spent a couple of years just trying to understand what fracturing was, looking at a bunch of diagrams, talking to DMME, talking to independent oil companies and gas companies. I will say this, it takes up a lot more time than any of us thought. Clear your plates. We were actually undergoing a massive comprehensive plan rewrite during this. Bad idea. I think we really burnt out some of county staff, with apologies to them. Definitely need clear definitions and terminology. I will say this, depending on how you ask the question, you will get different answers. And so it was really hard nailing some of the different people down on exactly what they meant, because the answers would move, especially over the course of 3 or 4 years. Different parties would train themselves to what you were looking for, and their answers would get better and better. So definitely be aware of that sort of thing. Understanding the physical components, highly recommend visiting sites, particularly in West Virginia. We had a few people go up there. Ann had some great examples. The sites can vary wildly in size and composition with what kind of ground disturbance they create. We saw some sites that were 15, 20 acres in size. We saw some that were maybe 1 to 2 acres in size. So again, they will show you pictures of what we call the Christmas tree, which is the little valve sticking out of the ground. A lot of active well sites don't look like that when they're done. So again, go out, do your own research, see for yourself. Don't take either side's word for granted on this. Definitely take care in defining accessory structures and usage. There's a lot more to it than just wells. There's condensation plants and things like that you'll see, particularly in West Virginia. Saw one condensation plant that was probably as large as any industrial plant we have in Washington County. So definitely look at accessory uses and what they need to perform beyond just the drilling component. Simple stuff, be ready, larger rooms, good AV. Some of our meetings, we had probably a good 3 to 4 dozen people standing in the hallway outside the room trying to hear what was going on. So we got a tremendous amount of community involvement. Get the ground rules out early. Make sure people understand how the meeting is going to be run. We sometimes are a little less formal in Washington County to encourage people to participate. That was a bad thing early on, so we definitely tightened things up, got better at our processes to make sure that people played by the rules, were respectful of each other's times, things like that. And spend a lot of time helping the public understand the process. Definitely, we actually got into a method where 5 minutes before the meeting, I would actually step up to the mic and explain to people what was going to happen, what public comment was, what the actual is being heard, when people should and shouldn't speak for things to make the best use of their times. So that was very helpful. Definitely be as transparent as possible. We all know that, but this is a good way to reinforce it. Again, the Dropbox site that our director of planning did was big to that. If someone gave us something, it went there to where there was proof that it was documented and no one really had any questions that things were being done behind the scenes without their knowledge. Consideration of ordinance enforcements and costs. This is one direction we went down. We started going above and beyond what DME required. Bottom line, we don't have a good enforcement mechanism and no way to fund one currently in Washington County. So be careful that you might get what you ask for and then really have no way to provide for that down the road, which negates the effort that you put into it. I will say this, forgiveness to anyone that works for the state. Once the Cuccinelli opinion came out, especially, complete lack of direction and participation from state agencies. They wouldn't even return our calls. We would invite them to our meetings. They'd flat out tell us, we're not going to come. We're not going to talk about this anymore. A lot of difficulty in tracking down, who regulates this, who regulates that. They just bounced us around all over the place. It was very, very difficult. In some cases, we never got satisfactory answers from state agencies as to what needed to be done.
Could you tell us again what that Cuccinelli decision was?
Briefly, and correct me if I'm wrong, the Cuccinelli decision basically said that the county could not prevent gas extraction through zoning, that we could regulate siting, but we had to allow the process. So where are we now? Since the ordinance was passed, we have had 0 applications for special exception permits. We've had 1 landowner inquire about the process. Some of this, the group believes, is because the market in natural gas dropped out right after the ordinance was passed. So we don't think the economical feasibility is really there where it used to be. And of course, Ann's already touched on the new AG opinion that could possibly change things for us. So again, interesting process, definitely something more heavily involved than we've ever seen. In the Dropbox, you'll find an ordinance from Longmont, Colorado that I referenced earlier. We thought that was a fantastic ordinance. It brought a lot of things to the table we hadn't considered, so you'll find that as another possible reference point. And last but not least, the 3 folks that really made the whole process run, Sheriff Marshall, Kathy Freeman, and Lucy Phillips. They're available if anybody has questions. If you have something you'd like to discuss specifically with them, they said all make themselves available as best they could to anyone here if you'd like to discuss something that Washington County did. So that is my whirlwind tour. And we've left a few minutes for questions. So, anybody has anything for Ann or myself, please? Yes, ma'am.
Question I had, when you said the oil and gas board and DEP we had them on the, not the opponents list, I guess, would be supporters list. Are those bodies supposed to be unbiased, objective bodies?
You would hope. Gas, DME, I can't talk to you. DME probably played the middle ground better than anyone else. Gas and oil board was very much upfront about their agenda. They didn't make any bones about it. They were pro-gas. I made the basically correlation, much like the forestry department being part of the Department of Commerce. It kind of lets you know where their head's at. They're there about making money, they're there about economic development. But again, they were very honest about their position. They weren't trying to be deceptive about it at all.
Second question, everybody keeps talking about, okay, we've had all these, we've had hydraulic fracturing, we've had oil and gas wells drilling for, 60, 70 years. But there has been a fundamental change in the process in the last 10 or 15 years, correct? And so the oil and gas wells that you have now in fracturing you had in the past, that was predominantly water stimulation, not chemicals, not horizontal. Am I correct on that? And there has been a process change that has increased and heightened awareness about the potential for chemicals and failure and that sort of thing.
Correct. I'll speak generically because I don't want to get us out of bounds over my expertise lies. There have been a lot of technical changes in how the drilling occurs, particularly with the fluids that they use, lubricants and things that they're using. A lot of the controversy around the fact they won't disclose, and they're exempted by a lot of federal regulations too. They don't have to. And also because of the horizontal drilling, which is it's not new, but it's relatively new. We certainly have seen it in our area, where a lot of them they're coming in like with the early growth gas fields saying we can refract these wells. We can go down to horizontal drilling and refract them with newer technology and get to a lot of gas that they couldn't before. So the technology is definitely improved from a production standpoint, but it's also raised a lot of questions as far as what are the components that make up the chemicals.
And I also add the intensiveness. It's the scale of production. If you look out west, where they're having a lot of issues with things like earthquakes, the scale of production is tremendous compared to what it had been historically. So even on top of the technological advancements, you might even have just sort of bulk as being a problem. So You know, I think, as Andy pointed out, we don't necessarily have those issues here. We do some technical guidance about the availability of gas and oil being in the ground. It's geographically maybe not supportive of such an intensive drilling operation.
Is there some sort of precedence for where a landowner's rights and going down, you know, like into the ground? If my neighbor, we have horizontal fractures, and my neighbor lets them drill, and then they go under my property. Is there anything on the books right now that really talks about where my sort of property rights and, you know, does it go to the court, or, you know, do I only have the enforcement?
You know, that's a really great question, and I wish I knew the answer to it, but I don't. I mean, generally speaking, you know, you do have the, you know, the mineral rights that are under, you know, your property goes all the way down. So if your neighbor had it and wanted to drill horizontally, you know, to what extent they could do that without getting that approval from you. Again, we've talked a little bit, and I don't want to say that I'm an expert in the pooling. That might, you know, so I think that there are some regulations that speak to that, which probably.
I can share with you one thing happened in the West Virginia legislature. They have an association, organization of not property owners, but mineral rights owners. And that's what the forced pooling is. If you're not cooperating, they come along and force you into that pool. However, the president of that association was supporting the legislation for forced pooling, having negotiated a threshold of higher, like you said, Virginia's 60%. West Virginia was proposing 80%. In other words, you had to have 80% of the owners on board before you could force the remaining 20%. And there were other provisions that, you know, also guaranteed some minimum level of payment and all that. But like if you're one of those people, it's like the little old lady in New Brunswick, Connecticut that didn't want to sell her property, you know, for the mall. I mean, they come on and take it anyway, and that's what they're going to do if you get forced pooling. But there are people who are in that position who are favoring it because they see economic opportunity, and they come up to the table and negotiate provisions which they feel to be to their advantage.
And I would add to that, and the reason I mentioned, you know, because it does have connotations of eminent domain, you know, in it, which, you know, the
Well, that's
law
what
on
they-
eminent domain has changed.
Yeah, that's
You
what
know,
I
speaking of New London and Kilo in those cases, so, you know, does that now change, you know, state legislative ability to require this forced pooling? If it's, you know, then I guess begs the question is, you know, is energy, you know, and natural gas, obviously it's, you know, it's gonna make the utility companies money, but is that a public
Well, that's what I'm
interest
saying.
for which, you know, you could exercise eminent domain? I think it's a great question.
Yeah, they had a few Republicans who said, Fifth Amendment, guys, we're not going to go along with the rest of the majority of this, and therefore it failed.
Well, we'll see, perhaps maybe this will be a topic for the next session. We have the eminent domain folks coming up, and perhaps we can have them address that.
Well, just one quick comment. I think this is something that both as county officials and as citizens remember. You talk about forced pooling, but think of what happens before that. The gas companies are coming in to get leases. Once they own the leases, that's the percentages that you're talking about. So they don't need to get all the landowners to drill a well. They need to get one landowner to let them drill and get access to those leases after they're pooled. So you see what the gas and oil companies do is they wind up getting a much, much smaller area of emphasis. They need to be able to control and get at those resources. I think a lot of people, when they sign those gas leases, don't understand that process. And later on, have some buyer's remorse. In fact, I really wish I hadn't done that because they have no control over the process after it's done. So keep that in mind if your municipality sees anything like this going on.
Well, it's a developing story. I guess we'll be waiting for some more lawyers to be involved. We'll be waiting for some more localities to draft and float some ordinances and some permits to be filed and see how those go. So we'll continue to support this as an educational thread. If you all have questions that we haven't been able to address in this session, please stay in contact with us. We'll try to connect you with the right resources. We'll try to push some of these questions to folks that may have answers, or at least can continue the dialogue about this. So the more we try to work through these issues, I think that the quicker we'll find ourselves some solid answers and some solid ground. So let us please thank Andy,